Good morning, everyone.
Good morning, and welcome to the January 9th, 2025 meeting of the Management Labor Advisory Committee meeting. I am the co-chair for the management side, Patrick Priest, and as we do at each meeting, I would like to start with an affirmation that we collectively, management and labor, agreed upon to start each meeting. We would like to thank everyone for their time, effort, and participation in our work before us today. We want to recognize that it is very difficult and important work, and we appreciate and value the perspectives and professionalism that everyone brings here today. Thank you. And with that, I will ask our administrator, Terry Watson, to do roll call.
Sarah Merrick. Here. Scott Strickland.
Present by video.
Margaret.
Here.
Lauren Pulling.
Present online.
Sarah Duckball. Ryan.
Present.
Stacy Llewellyn.
Present online.
And Co-Chair Priest.
Here.
Kim. Here. And Director Stolpe is in Washington, D.C. and sends his regards. Okay.
All right, thank you for that. So we do have a quorum if we have any business. The first item on the agenda is to review minutes from the December 5th, 2024 meeting. And I would ask if there's any discussion. And I see Margaret.
I did. I had a couple of questions, and frankly, I just didn't have time to get back and listen to the thing. And so if we could put this off a month to give me more time to review it, I apologize if everybody else is ready.
Okay.
Margaret, we'll be back in 2 weeks on the 23rd.
That's what I thought.
Okay.
In 2 weeks, okay. Do you need a month or is 2 weeks?
In 2 weeks is fine. I can get it read by then.
Is anybody burning to approve it today, or is it okay to wait? All right, online?
Margaret beat me to it. I was also going to request a stay of 2 weeks prior to voting.
Okay, so now we know who the two slackers are.
Okay. All right. All right, well, with that, we will defer that agenda item and move it to our next meeting. And
Sarah Larson. Sarah Larson.
okay, all right, thank you. And then our first department update is the Workers' Compensation Board case law update. And we have Sarah Larson online to give us that update.
Hi, thank you, co-chairs, members of MLAC. At this time, we have no updates from the board.
Are there any questions from anybody on the committee? Okay. All right, well,
I did have one quick question.
Sure.
We used to get case notes and management from the board, and I noticed that we haven't received those, at least in a packet. Are we not getting them, or if we're not getting them in paper, can we get them a link to the board's case notes and announcements sent to us?
Definitely.
I'm
yes.
assuming
We can get
that the case board notes are still coming out monthly.
Yes, those are coming out monthly, and we can definitely give you a link to that. And then also my manager, Lauren Eldridge, is going to be giving an update on cases here. I want to say within the next 2 weeks at the next MLAC meeting.
Yes, Lauren had talked to me about the update,
Okay.
but she just couldn't attend this meeting. So,
Okay, thank you.
All right, good question,
Yep.
Margaret. Thank you very much. And thank you, Sarah, for being here today.
Thank you.
All right, our next item on the agenda is a Workers' Compensation Division update from Terry Watson.
yes, I'm so excited to share this update. I've been meaning to share it for the last couple of meetings, but we've had other things take precedence. Can you show the screen? This is the new Spanish website. Here's the notice of compliance in Spanish with the QR code, and then it'll take people to the new Spanish website. So we are so happy with this. So I just wanted to let you know, I think it was completed in November, but again, with all the things going on, I haven't had a chance to show you. So here's the Spanish version. Here is the English version. Pop on the QR code and it'll take you to this website. So
Awesome.
kudos to you all. Great job.
Where do we get these posters?
Pardon?
Where can we get these posters?
When these are being ordered soon, the English ones are complete. If you need an English one, you just normal call in or how you order them, and then they come out with your business's information, insurance information are ordered now. The Spanish ones are being ordered soon, is what I understand, because we have to go through the ones that we have before we order new ones. So, but if you want one, we can go ahead and make you a copy and get it to you.
Great. Can you send them out to us?
Yes, I'd be happy to.
Both Spanish
Yeah.
and English? Thank you.
Thank you very much. Good work with that. I have a question. Do you monitor usage of the websites? Like kind of track how many people access them and what they access?
I don't know. Yes, we do.
Okay. Yeah. So is it used, the Spanish one? Is it since November? I don't know. Has it been used a lot?
I don't know that we've pulled any data on it. We
Yeah.
can certainly check. Our communications team handles that. We can ask them if there's been any traffic on those pages yet.
Yeah. Might be nice to know what people are interested in.
Yeah. Okay, I will follow up on that for you.
Thank you for that. Sorry to spring that on you. I
It's
was
okay.
inspired by the website. So.
Okay, all right.
All right, the next item on the agenda, I think it falls under department updates. There was an announcement by Director Stolfe last time about a sweep of funds from the Workers' Comp Benefit Fund to go to BOLI. And there were some questions, subsequently, and the co-chairs did ask Terry Watson to bring some information forward. And I understand Matt West is gonna to make a presentation to give us a little more information on the transfer and on our role as MLAC in evaluating.
Yes. So thank you, Co-Chair Priest and Strickland and members of the committee. So Matt West, Interim Administrator of the Workers' Compensation Division. As you mentioned in the last MLAC meeting, Director Stolfe gave an update and shared that the governor released her recommended budget for 25-27 biennium. And within her budget, she's recommending a one-time $15 million transfer from the Workers' Benefit Fund to the Bureau of Labor and Industries to help support their programs and services. And then some follow-up questions from you also. Here to address those to the best of my ability. We provided Terry sent out a memo with some of the information. So I'm going to sort of use that as I share the information, and feel free to ask any questions as they come up. So some of the questions around the uses and limitations of the WBF, MLAC's role related to the WBF, including statutory duties related to the fund, and then also history on prior fund sweeps. So we have that information in the memo. If you're okay, I'll walk through, kind of made some notes related to that. So first, I think before I get into the memo, I think it's important to note that the proposed $15 million sweep currently is in the recommended budget. And so that still needs to go to the legislature for approval. So it's not necessarily a done deal right now. It's needs to be approved by the legislature before any funds would be transferred. Also wanted to share, and I think Director Stolfe mentioned this in December, that if the transfer is approved by the legislature, it wouldn't have an impact on any benefits to injured workers or any of the programs paid out by the WBF. The WBF has a healthy fund balance of $136 million as of the end of the last fiscal year, which is a coverage ratio of about 7.5 quarters. So almost 2 years. In other words, almost 2 years of funding for the current programs are in the fund. If no more revenue came in, we have enough money in there to cover the expenditures for the next 2 years. This is important to note also that it wouldn't impact the WBF assessment rate for 2025, which is set at 2 cents per hour. So we set that annually. There's a review process that we go through. That has already been set for 25. Any future potential increase would be determined as we go through the rate setting meetings later in 2025. And if the sweep happens, we would take that into consideration as whether or not we needed to raise the current assessment for 2026. Any questions on that or the rate setting process?
There's no guarantee that, $15 million sweep isn't going to result in a rate increase.
There's no guarantee that it wouldn't result. It won't in 2025, but
Right.
it could for the future.
Yeah.
Exactly. Yeah. And we would that's one of the components that we would take into account when we do the rate setting is the balance. So by the time, if that happened, our rate setting process happens in the fall, 15 million would already be out of the fund. And so we would take the current balance at that time, along with projected expenditures, projected revenue, and determine whether or not an increase would be needed for 2026.
Right, so you said we have about 2 years
Correct.
in there. With the exit of 15 million, what would that put us at?
I don't have the answer to that right now. We can flag that and see what that would put us at. So 100, well, we could do some math and tell you what that would be.
It would reduce the reserves.
It would reduce the reserves, yeah. And then if I have some notes here, and I'm going to get to that, but also just for what it's worth, statutorily, we're required to have 12 months or 4 quarters of balance. So we're above our limit. The 15 million wouldn't drop us below the statutory minimum of 12 months. So it wouldn't drop us below that. We'd still be above, but then the effect would essentially be how quickly, if we didn't raise the rates, or depending on revenue, how quickly the fund would spend down. Yeah. So we'll flag the question and send some follow-up.
I have a follow-up question. Has there ever been a rate decline, a decrease? Has that ever been
The rates
proposed?
have decreased.
Yes, and they have. And part in the memo that Terry provided, there's a link, and you may recall our senior economist came last April, for those that were here, and gave an update on the Workers Benefit Fund, which we do each year, I think. And there's on that, so the link at the bottom, there's a chart in there that shows historically what the rate has been. And so it's been 2 cents. We lowered it to 2 cents in 2024. So in 2025, it's staying at 2 cents. Prior to that, which is the lowest it's ever been. In the 90s, it was 4.2, and then it's declined. So we're in a good spot. But yes, there has been decreases.
Thank you.
Yeah. Any other questions on this? Right. Okay. So as far as the uses of the Worker Benefit Fund, those are listed in 656, 605, and we provided all the statutory language towards the end of the memo. And so, again, when Kelly, our senior economist, comes and presents, she usually goes over the programs and expenditures. So I pulled some of the information from her memo to supplement kind of what we have in the memo we provided you. WBF expenditures average around $77 million per year. That's for the last 5 years. That's been about what the average has been. The 2 largest programs funded by the Workers Benefit Fund are, one, the retroactive program, which in the last fiscal year was $39.7 million, or 54% of the WBF program expenditures. And this program provides increased benefits to workers or their beneficiaries. Those increases are received mainly by beneficiaries for workers who suffered fatal injuries or by workers who've been determined to have permanent total disability. The next largest expenditure is the Reemployment Assistance Program, which includes our Employer Injury Program and Return to Work programs. And that's about 29 million, or 39% of the fund. So those 2 programs, the vast majority. And those, the Employer Injury Program and Preferred Worker Program, provide employers incentives to rehire or hire injured workers, and then also provides benefits such as worksite modifications or other employment-related purchases to assist injured workers in getting back to work with either their employer at injury or a new employer. You may recall, if you were at the meeting in the Dalles, we had one of our program experts come and give a more detailed overview of those programs. So that's where those programs are funded. The non-complying employer program is listed on the memo for a reason, but it's important to note that the WBF assessment doesn't fund the non-complying employer program. But the funds for that program are housed within the WBF. So revenue from non-compliant employer recoveries, fines, penalties go into the WBF to cover non-compliant employer claim expenditures, which are payments to the claims administrator that we have a contract with to process those claims. So they're paid out of the WBF fund, but not with the WBF assessment. And then at any point in time, if the recoveries dip below what the expenditures are, then a revenue transfer from our other fund, which is the premium assessment operating account, or PAOA, would be moved, or funds would be transferred from the PAOA to the WBF to cover those, because statutorily WBF assessment money can't be used to pay for that program. That makes sense. Mm-hmm. But it's within the money's within the same account, essentially. Just wanted to clarify that because it's on the list. And then some smaller programs, reopen claims program, about 3.5 million a year. There's a revenue transfer for the Oregon Institute of Occupational Health Sciences. They come and give an annual presentation. They were there in the Dalles. About 1.9 million goes to them. And then currently there are already some funds that go to BOLI, and that's for the enforcement of anti-discrimination laws related to retaliation or reinstatement rights. So if a worker's retaliated against by their employer for filing a claim or inquiring about filing a claim, BOLI would investigate that, and then they would send us the bill, essentially. So we have an interagency agreement with BOLI, and we pay those on a per case basis. So they tell us all the cases that they investigate, we review them, and then we pay them for those cases. And we have, like I said, we have an interagency agreement. I believe the link is in the memo as well, if you're interested in looking at the interagency agreement.
But let me send you the new one, because this link is broke.
Yeah, we tested it this morning. There were some links that weren't quite working, so we'll get you an updated one. And if it's not working on the updated one, please let us know. Any questions on programs that are funded out of the? Oh, one I didn't mention was supplemental disability benefits, which is about just over $1 million a year.
Are these the like statutorily what the fund is used for?
Yes,
or
and
is it open-ended as to what it could be used for?
It's very specific in statute what it can be used for, and that's it's 656605, which we provided the language, and it lists out what programs can be used for. So if we had a great idea and think, hey, we have some money here, we could use it, and let's use it at BF, we're not allowed to do that. So specifically listed programs that can be used.
I do have a question, just because it's been on my mind since the injured worker panel, and I saw it based on here, the payments due to workers who have not received payment from an insurer in default. How often is that fund used, or how do workers access that fund when Robert Austin, the individual that shared that he's constantly been in default, or his insurer has constantly been in default and super late, affecting his credit score and all of that? It's just been on my mind this whole last month of how do that just is just in the not right. But so how do workers access that if since it does look like there is a fund for that?
Yeah, and that's if an insurer, and I will get more information, but it's not on your normal like claims process. It's certain insurers that I believe, well, I don't want to share any incorrect information. So we'll get some more information on that specifically, on that specific program, and send that to the committee. Yeah.
How many insurers are in default? Do we know? I mean, is that a knowable thing? That seems like a very rare thing. I don't know.
Right.
I hope
it is rare. So that's why I was saying it's not necessarily that a payment was late. It's like the insurance company is actually in default.
Going bankrupt.
Yes, which doesn't happen very often. So the case of a worker that isn't getting their payments, that would be something that, as a division, we'd want to know. We have some enforcement mechanism. We could penalize the insurer if they're late on payments and things like that. But that's different than an insurer being in default. And then the other worker, one of the workers that presented to the committee last month talked the non-compliant employer. So that's how their claim would be processed and paid for, as I mentioned.
Kind of building on Sarah's very good question. So there's reserves set aside in the event an insurer goes default. And like, that's kind of a rare thing, but if it was to occur, that could be a big hit to this worker comp benefit fund if they have quite a few open claims. And so it seems like that's an important use, sort of a catch-all to protect workers in the event a company fails.
Yes, and that we can get more information on that. That's an area I'm not well versed on. It's very technical.
Yeah, yeah, thank you.
But we have experts that know a lot about it, and we'll provide some information on that.
Yeah. And then one other question. So this suite, how does it fall within the statute? Since you said it's very specific, what part of the statute does it fall under as an appropriate use of the worker comp benefit fund?
It doesn't. So that's why it's like we couldn't, if for example, the governor said, hey, can you give $15 million to Boley? We would say, we don't have the authority as the director and the, managing the fund, because it only allows us to do certain things. I don't know the authority or where the governor and the legislature get the authority to sweep funds, but it has happened. And our deputy director's here who knows a lot more about that than I do. So
I'm happy to answer that question. Mr. Priest.
Yeah,
Appreciate
yeah,
that.
you too.
Good morning, everybody. Sean O'Day, Deputy Director of DCBS. Because the legislature is the one that set the statute and the statutory limitations on how the fund can be used, they have the authority to amend or reallocate those funds. So as Matt was saying, we can't do that at the agency level, nor does the governor have plenary authority to do that. But through the adoption of the budget, the legislature can essentially redirect funds out of the WBF and has done so several times over the course of its existence.
thank you. Phone a friend.
Yeah, thank you for being here.
Any other questions that I may or may not be able to answer?
Yeah.
Okay, so I'll got a couple other talking points, and then so as far as MLAC's role, we shared the statutory language in there, right? And so 656790 talks about MLAC has the role to advise the director regarding any proposed changes in the operation of programs funded by the WBF. So if we were going to do some sweeping changes, or we would, we would come to MLAC and discuss those and seek your advice. Also, MLAC's responsibility to review any plan that, as an agency, we devise to increase the balance of the fund to meet minimum requirements. So if we were going to dip below that 12-month statutory requirement, and we would, statute requires us to come up with a plan and then seek your advice and counsel. There's also another statute, well, later in that statute, sub 3, says the committee shall report to the Legislative Assembly such findings and recommendations as the committee considers appropriate, including, and then there's a list of certain things, and one of them is the operation of programs funded by the WBF. So if there were findings and recommendations that MLAC has that they want the legislature to consider, that would be within the committee's role. And then, as I mentioned, the 12 months, there's another statute that's in, I think, 506 that talks about if it goes below 12 months, then we seek advice from the committee. And then as far as information on previous sweeps, so we dug back, and the last time the WBF was swept for purposes other than those listed in 656605 was in 2003, and it was part of House Bill 5007, which was related to a reduction in employer PERS contribution rates, and $251,152 were swept from the Workers' Benefit Fund. That's the last sweep from the WBF.
There was a question.
Yeah, I apologize. I was digesting what Deputy Director had mentioned before. He had said that the WBF had been pulled before, funds had been pulled before from the WBF. I'd like to know more about, when that occurred, what was that pulled for, and how much.
He just told us.
Oh, he did?
Yeah,
I'm so sorry. I was probably digesting as you were going through that. I apologize.
No, I'll rewind and
Yeah. 251,000.
It's on the bottom of the memo also.
Oh,
But yes,
really?
it was,
Okay.
last time it was swept was in 2003.
I
Yes.
appreciate it.
No, you were reading and
You're on top of it.
not a problem.
Thank
So
you.
far less than 250,000.
251,000 and change.
Did you raise your hand, Ken, or just took your glasses off? I thought I saw like movement over there. Did you have a question? No. Margaret?
And this isn't directed specifically to you, but thank you. As I was reading this, I don't think that I had really appreciated 790 sub 3 about our responsibility. So as I was reading through this, I went to our website and I was hopping around the website and I can't find any previous reports. And after being on the committee for 4 years, I don't remember ever participating in a report. So can you help me? I mean, not you, I mean,
Yeah.
I'm directing this more towards Terry and Patrick. Can you guys help me out with?
Yeah, we're gonna phone another friend, yeah.
Another lifeline.
We're gonna phone another friend.
There's benefit funds, don't we get those reports every year in the fall?
Yes.
But that's not the same as.
It's not the
what
same,
I'm
yeah.
You're referring to
talking
like a
about.
report to the
Yeah,
legislature.
but I can explain this. Hi, everybody. For the record, Teresa Van Winkle, Legislative Director, DCBS, and former MLAC Administrator. So, Margaret, to answer your question, it actually is kind of the statutory authority for most of the bulk of what MLAC deliberates on. So, for example, the legislative review process and the subsequent letter with your recommendations to the committee in which a bill is in, that's part of this. Any directives, so for example, not jump further ahead in the agenda. If a bill doesn't go forward and a committee chair or interested parties are asking for MLAC to do a further deep dive in like issues that are contained in a piece of legislation or a public policy topic, that's part of the process as well. And so reports are generated from that. Or also any ideas specific to the workers' compensation system that you generate, for example, the reports from subcommittees and final deliberations there. And the WBF report and other reports, also the PPD and PTD reports fall under this as well.
So when, for example, a couple of years ago, we did quite a bit about the medical and where there was, Matt and Sarah did a lot of work. Did you fill out write a report for the legislature regarding your subcommittee?
I don't know if a report was written.
I
I mean, we reported back to MLAC.
There was
We
reports.
reported-
I don't know at my fingertips. I will look into the records because I don't recall right at the moment what the next steps were.
Okay.
I know there was conversations. I just want to make sure that I don't want to speak out of turn in regards to any formal summaries and where
It
they
was
were
going
doing.
back to MLAC. From the subcommittee.
Our reports to the legislature are pretty much limited to, we've agreed on something and then you or you would write up a letter that we would sign and you would distribute it to whoever needed it.
Yeah, and there are times too, I mean, the most recent, and probably the most prominent example that comes to mind in regards to formal reports were the subcommittee, the committee during the pandemic looking at COVID. There were the two asks, one from the governor, one from the legislature for reports. And so those were delivered as well. I can say this too on the legislatures and where that goes. So they go to legislators, committee chairs. There's also a central resource in which reports, not just specific to MLAC, but all state agency and advisory bodies. There's a central thing for that. And committees can choose to have formal report, like hearings, for example, for MLAC to provide background on and be able to answer questions from reports.
So I'm hearing that MLAC has the authority to issue a report based on its own opinion. They could just disregard it, but we could issue a report if we wanted to in this matter, if there was interest. I don't know, is there, I guess I'd maybe pause on that before we explore that. Is there interest to explore this further and provide some kind of report on this transfer?
I have interest.
Sarah and Ryan. Anyone else? Those are management.
Yeah, I was going to
Caucus
say,
members.
I feel like I know to check in on.
So I would have interest as well. I don't know. Scott or Lauren on the line, do you have any comment at this time?
In speaking with the Labor Caucus, I don't think that this is as concerning an issue for us because we see value in if it's a worker benefit fund. This is definitely going directly to worker benefit in one way or another. So I don't I have not heard from us nor our stakeholders yet of any concerns about this sweep or precedent or any of that. I'm happy to beat the street again and see, go around and connect with everyone. But and if management insists, we're happy to be a part of kind of writing an opinion piece on it. But yeah, I haven't heard any criticism or concern about it yet.
Thank you, Scott.
Yeah, and what I meant was if there's going to be a piece and if you need a labor participant, I would be happy to work
To
with,
participate.
to
Well,
participate.
thank you for that. Is there enough interest to explore further and determine if a report maybe would be appropriate at a later time?
Yes.
So bring it back to the agenda on the 23rd. Is that what I'm hearing?
I think so. I think, and then we'll wait and finish the report that you have, but maybe have, if there are things that we would like research on, or
I would like to know the number where reserves will stand post transfer if one occurs.
Yeah, we can make a note of that, and any other data requests or number requests, we can talk to our financial folks and provide
Okay,
that.
so the post, I just want to make sure. So we had the post sweep account numbers. You also had the question about the when the insurer goes bankrupt.
I think just kind of expanding on that, it would be, is there a status of insurers? I mean, there was at least one that insured somebody that presented to us last time around.
Okay.
How many insurers are in default? And are there some that are near that point that you're monitoring, so that we would kind of get a sense of what impact that could be to the worker comp benefit fund? I mean, I would be curious in that.
I heard Matt say that it's about 77 million a year through this fund. I would like to know at what point typically we see rate increases, at what reserve level. That question makes sense?
Yes.
Just the history of when increases happen. I know we're at a very healthy reserve balance now, but with the out transfer of funds and a potential increase to employers, I'd like to know that history. As we're not part of setting that.
Yeah, and in that link with the annual report, you'll find some information that may be helpful as well. 2013 was the last time it was increased.
But where were we at?
Right, and that's, we can follow up on that.
Okay.
Maybe timeframes, when they're going to be looking at pulling this money, and how quickly do we need to get it in front of the government?
That's a really good question. I can answer that. Yeah. We have to see, because to jump further ahead, I guess I don't want to blend what's really the agenda on the legislative process and together. But budget, so everything has to be included in a bill. It's just something that's not like an arbitrary decision, and also has to be voted on by both the House and the Senate before it goes to the governor for her final deliberation. So it could be really at any time, and I don't know if it could be something within the Bureau of Labor and Industries budget. I don't know if it could be within our agency budget. We're not responsible for the bill language. We just know it's assigned a bill number, and we'll see that when the pre-session file bills are available. It could be literally an end of session bill, or more colloquially called the Christmas tree bill. So it could be something that we won't know until the very last few days of session. But it's one of the things that I will be monitoring. I know that there's others at WCD and the agency they'll be monitoring as well. So we can provide updates too when we see that.
Great, thank you.
Yes.
So if the money does get swept over into the bowling, how is that money going to be used? Do we have more information how bowling would use that money? If it is for workers, then maybe it's this would be okay. But do we have any idea how they're going to use that money?
I do know, speaking from the governor's recommended budget document, the purpose for the sweep is to help in regards to current existing positions at BOLI related to the processing of casework. That's what I believe, it's more broad terms, but my understanding, that's what it's for. It is to process workers' claims in regards to their rights for both, not just in the workers' compensation system, but also with Oregon OSHA as well.
Is it fair to say just go to the Civil Rights Division?
Yes,
For the
and
cases?
I was gonna say, I think in a response, I can help work with WCD in providing basic background on how that works too, because although it is within the workers' compensation system, the Bureau of Labor and Industries does handle that under their Civil Rights Division. So we'll include that as well.
Okay. Any other questions or comments online? Is that the end of your
That's
presentation?
it, yeah,
Okay.
it's perfect timing.
All right, well, thank you for that.
Thank you.
Interest at least from some. You answered it. Thank you very much. All right, well, so we'll bring that back to the next meeting. Moving on, we have some legislative concepts, all from the Oregon Trial Lawyers Association. And so I would like to call forward Keith Semple and Giovanna Patrick, who are on my agenda, to present 3 bills. And it's, thank you very much for coming today.
Good morning.
Good morning.
Good morning.
I think that clicker should work for you, but if it doesn't, just let us know.
Okay,
Just a second. We're having technical difficulties with your PowerPoint. Sorry.
oh, that's okay.
How are you today? How was your trip up? There we go.
Better than usual.
Okay, great.
It was a nice day for a drive.
Yeah, it was beautiful outside, wasn't it? How you doing, Bella? Are we good? Okay. All right.
So I'm Keith Semple, and this is Giovanna Patrick. We are the co-chairs of the Oregon Trial Lawyers Association Workers' Compensation Section. The Oregon Trial Lawyers Association actually goes back to the beginnings of workers' compensation as an organization that started among attorneys who represented injured workers. Since that time, it's grown to include a lot of other practice areas for people representing individuals. We're proud to carry on the tradition where the organization started and continue to work on behalf of injured workers to try and improve the system. We have 3 proposals to present, and Giovanna's going to go ahead and start us off.
There we go. So starting off with just a summary of our proposals. Thank you for taking the time, everyone here who's come to listen. And of course, their proposals. So we've listed them here and we'll go through each one. But LC 2160 is providing interim disability benefits to workers during the non-compliant employer investigation. LC 2375 is providing all workers equal access to their impairment compensation during their vocational training programs. And then LC 2272 is providing parity in the dispute expenses. So starting with parity in wage replacement, I've got a quote there from the ORS that talks about non-compliant employers. Hopefully everyone knows here, so we've been talking about for a while, but of course all employers are supposed to buy insurance, and the folks that are here in the room are employers who are following the law. We all know there are employers who don't follow the law, and unfortunately, the workers who have no control over that tend to get the short end of the stick. I heard some powerful testimony last time from some injured workers who had gone through that process, and we feel like the state needs to help take care of these very vulnerable workers. I tend to represent a lot of them because I have a bilingual English-Spanish practice, and I can tell you this falls a lot on the immigrant community, on the low-wage community, people of color, people who don't speak English as a first language. They get really taken advantage of by employers who aren't following their law. And they're not being treated the same under the law, even though our statute says that they are supposed to be treated the same. And so if we move on to kind of compare what these workers, how they have a different situation. So if you work for a complying employer, everything's going fine, then, you get injured, go to your employer, you say, I've been injured, the employer gives you an 801, sends that to their insurance company, gives you some guidance on what to do. That insurance company has to contact the worker within 5 days. And then the worker receives interim disability benefits starting on day 14 from the date of notice and assuming they have a disability note, of course. And then they get that money during that first 60 days of investigation. Now, a worker for a non-compliant employer has a completely different experience going through the system, especially right at the beginning when benefits are at the most important to prevent these workers from falling into financial distress because of their injuries. If you work for a non-compliant employer, You get injured, your employer probably doesn't help you file a claim. Some employers just say, I don't have insurance, sorry, here's the state, but most of them don't. What I hear stories of are promises to pay. I'll pay your medical bill, just tell them you fell at home. I get lies, oh, we have insurance, I just can't find it. We get intimidation, don't file a claim or we're gonna, call immigration on you. We get people who get promised things and then treated as if they never worked there in the first place or fired. I had one once where she worked at a restaurant and was cut her finger badly, and the employer said, we don't know this woman. We've never met her before in our lives. She's lying. She went to the restaurant with the WCD investigator, and the customers were like, Maria, hi, where have you been? We've missed you waiting on us every Wednesday night. So that's the sort of thing that happens across the board. And so the worker has trouble filing the claim in the first place. So we have delays. And then they struggle to figure out how to file a claim. Hopefully they get to the ombuds or an attorney who helps them with that, but it's not very obvious for workers on where to go. And then once they finally make it into filing a request for investigation and figure out what they need to do, they wait up to 60 days for that investigation with no benefits of any kind. And then they wait again, if they're found a subject worker, for that to be referred over to Sedgwick. And then now we're back where the other workers are, waiting 14 days if they have a current disability note after all of that time that's already passed. And then they're back in the regular workers' comp process. And the importance of that first payment is so important. If you think about your families, your financial needs, if your spouse or one of your family members who contributes to the funds was seriously injured, couldn't work, and not getting that first paycheck, it's on top of these problems. So that first paycheck is of such importance to these workers, and the workers who are in a non-compliant employer situation wait an incredibly longer period of time. So solutions, and this is a work in progress, of course. We want workers to be paid interim disability benefits during the employer compliance investigation. And we see that these should be reimbursed through the NCE program housed at the Worker Benefit Fund. Seems like the most appropriate place to pay out those benefits. And importantly, WCB can still recover those benefits from the non-compliant employers the same as they do right now. And of course, injured workers would have to have their work notes just as they do now. There'd still be a process for that. And we looked at some numbers that show that about of the 3,000 or so NCE cases filed, I got about 91% of them we either find an insurance company or we find as a non-compliant employer, which means that the fund would pay those wage loss benefits, those disability benefits for 91% of these cases anyway. Like those would get paid, just at a different time for the NCEs. And so we want that to be done at the time when other workers also get their benefits.
The next issue that we've identified that we would like to address is creating parity between workers who go through their retraining.
Sorry, I have a question.
Yes.
Co-Chair Priest, can we address questions at each one, or do you want to?
That was a question I had as well. So there's 3 different LCs, and I don't know if we wanted to handle them one at a time.
We do have 3, and we also had the answers to the questions, but the MLAC questions prepared in general. So we didn't know if you wanted us to go through all of them with the questions and then have questions, or just you.
Yeah, I think we met as a group and like discussed them. So we treat each one differently. Is it okay? Are you flexible to take questions at each one?
Why don't I run through the frequently asked questions with regard to this concept, and then we'll do the next concept, and I'll go through those and then take questions right after I do address the frequently asked questions.
Is that okay, sir, or would you rather ask your question now?
Frequently asked questions regarding
The
2160?
Yes, the frequently asked questions regarding 2160. So how do these proposals support the value of MLAC, the values of MLAC? We're really focused on the fairness and adequacy of the benefits for the people that are involved here. We want to make sure that the workers get their benefits in a timely manner and have the same ability to survive, especially since many of these claims end up being compensable. I think we went through the specific problems that we're trying to solve. What causes the problem is either lack of clarity about who an employer's insurance is, or failure to carry insurance coverage when it's required. I'm not aware that this problem has been addressed previously, pre or post Mahonia Hall. The data, we have collected some data from the workers' comp division on this question in terms of how many claims are involved. It looked like there were about 3,000 total non-complying employer investigations from 2019 to 2024. Of those 3,000, only about 300 were either denied or withdrawn. So that would give you between 2019 and 2024 a sense of the scope of those 300 workers that wouldn't get a benefit and shouldn't have been claiming non-complying employer maybe anyway, or that's the number that would potentially be affected. And the division told us that about 19% of those 3,000 claims, or maybe 2,700 claims, had evidence of payments being issued. So in terms of how many of these claims actually involve wage loss that would have to be replaced, it's a small subset really of the 3,000, and yet a smaller subset of the 300 that don't actually end up belonging where they started. In terms of how many workers this problem affects, we've again got some data on that. We're talking about 3,000 workers or so between 2019 and 2024, and 2,700 who ended up having claims that went through and were found to be non-complying employer claims. It's difficult to say what the potential cost would be for the fund. It shouldn't add costs to insurers, I don't think, but it would increase the cost to the fund by the number of workers who would have had their claims denied as employer non-compliant situations. So it shouldn't be a real large amount of number. We've talked about the fact that 19% of those had payments issued, and the benefit would only be added to existing benefits for the investigation period, which is 60 days.
By the fund, do you mean the worker comp benefit fund that we just talked about?
Yes, and we understand there's some nuance in terms of how money is segregated to be used for the non-complying employer, and those are the types of things that we need to get a little bit deeper on in terms of addressing the language here.
Could this cost $15 million?
I'm not thinking it will. In terms of feedback from the Ombuds office, we have spoken with the Ombuds office, and the problem is acknowledged and recognized. And I do think that the Ombuds office supports the efforts to try and bridge this gap so that these workers don't go through what the worker that we heard from last session is going through. What stakeholders are affected? Workers would be affected. The workers' comp division would be affected in terms of having to administer the benefit. Normally, the claims are referred to Sedgwick for processing. They may be affected if the division decided to refer the processing of these benefits to Sedgwick at an earlier date. So there could be some administrative costs there that are difficult for me to predict, but that we'll be asking about and trying to flesh out a little bit. We have not talked to Sedgwick, but we have talked to the division about the proposal and how that would work, and we're trying to get as much feedback as we can on that piece of that. We've done what we can to research the fiscal impact in the ways that we've described here, and I don't think that it will affect things in a major way in the system in terms of the impact that we're talking about here. Questions beyond those?
Did your question get addressed?
In that period, how would you deal with litigation, and who would be ultimately responsible in that 60-day period when it's coming through the Workers' Benefit Fund? And how do you make sure the Workers' Benefit Fund remains whole?
Okay. Well, in the 60 days, you said, what about litigation in those?
Do they have the same rights of litigation, and where does it fall? What if time loss is ultimately deemed not found? How does the fund become whole?
If the coverage is found, is not found, you're asking. So if the coverage is, if the worker is found to be, are you asking for workers that are found to be subject workers for non-complying employers, or workers who are found ultimately to be non-subject workers?
Let's say subject workers.
Okay, so if they ultimately are found to be subject workers, but the employer didn't have insurance, the claim gets referred to Sedgwick for processing, and the bill is sent to the employer, who may or may not pay it. And if they don't pay it, then the fund gets depleted in the same way that it does now. The only difference is, so those workers who file a valid non-complying employer claim and get these benefits, those benefits would be ultimately provided to those workers if they were actually in a non-complying employer situation under current law. The workers who would be getting benefits that aren't currently provided under law would be those workers who filed a claim, have a disability, and turn in their work limitations, and are later found, actually, this isn't a non-complying employer. You weren't a subject worker, or they weren't a subject employer, or in some cases, apparently claims get withdrawn. That's the only subset that would be adding a burden to the fund. That's the subject. That's the subset that would be getting a benefit that's not currently provided and that's not reimbursed. No one. I mean, ultimately, that is the burden to the fund. That is the added burden to the fund. Is 300 workers from 2019 to 2024. 19% of those maybe had claims. That's those for 60 days each. That's what the added burden to the fund would be.
We don't know a dollar amount on that.
No. The benefit was that we've proposed is 2/3 of the state average weekly wage. So we would be able to do the math on 60 days times 2/3 of the state's average weekly wage for this subset of workers. So we're close to being able to, I think, estimate those costs.
And if we set it on the state's average weekly wage rather than the workers, that would prevent litigation over that time period, because a lot of these workers don't have necessarily regular wages. Sometimes they're paid cash, sometimes they're paid in other various ways. So there shouldn't be a lot of litigation over the delivery of those benefits, because they're not based on getting facts from the worker, other than you got your disability note, you're going to get paid 66% of the state's average weekly wage. And then the other thing I just wanted to mention, we talk about the 60 days, and it sometimes does take 60 days, but in talking with WCD, sometimes it doesn't, right? Some of their investigations, they work hard to get those investigations out. So some of these workers who are waiting around during the investigation, we're not talking about 60 days. We might be talking about 30 days or 45 or something of that nature. But it just gives them that protection during whatever period of time that happens to be.
I think we got a report, it was an average of 50 some days.
Yeah.
So close to the 60-day limit.
Well, and I would draw a parallel with workers that are in complying employer with normal insurance claims. Some of those workers get interim compensation for the 60-day investigation, and the claim is found non-compensable. Who reimburses that? It's just built into the system. I mean, so if you think about the parallel, I can understand, well, no one's reimbursing this. Well, if you look at the two different workers the same way, no one's reimbursing in cases that are ultimately not successful, because you don't get the insurers don't get to send the worker a bill for their interim compensation if it was paid on a claim that's ultimately denied.
Any other questions on that one? None? Online? Scott Strickland, you've got a question?
Yes, thank you. I'm not sure if I don't think our friends at Outlaw would be able to help with this one, but in thinking about all of this and the compliant employer problem and situation here, I know that the presentation from, I think, the gentleman who was working for a roofing contractor that was not carrying work comp insurance. Do we have an update if they still have their CCB and are out there performing work with employees without work comp insurance?
Great question, Scott.
I don't have the answer to that, and I'm not sure that that's something, maybe Matt can speak to that, but not something that's necessarily tracked or followed up with by this agency.
Okay, thanks.
Yeah, I'm interested.
Sure.
Oh, do you?
Thank you, Matt.
Yes, you're welcome. Again, Matt with Interim Administrator, Workers' Compensation Division. So that particular worker, the employer was found non-complying. The claim was referred to Sedgwick for processing. The employer was issued a civil penalty and will ultimately be responsible for claims costs. It is, I believe, the employer is contesting it, so there's going to be some ongoing litigation referred to it or related to it. But our understanding in the investigation, it was sort of a one-off, like some guy's doing a job. So it's not an employer that typically, that no longer has employees, I guess, is the gist of it.
Okay, thank you.
Yeah.
Thank you. All right. Seeing no other questions, I think we'll let you go to the next one.
Thank you. Legislative LC 2375 addresses the payment of permanent impairment compensation and the interaction between that and being engaged and involved in a retraining program. Currently, the way things work is that if a worker reaches maximum improvement, the insurer has an obligation to collect the information needed to evaluate their permanent impairment compensation. So they have to collect information from the doctors. They have to provide the formula that's been adopted by law and convert the impairment factors to a dollar amount. Workers who have permanent impairment that limits their ability to return to work may be eligible for retraining. And they'd be eligible if they can't make 80% of their wage at injury with their current skill set and limitations. So you have those two different rights, but it applies differently to different workers. If a worker gets their impairment compensation determined and paid out before they start their retraining program, they get the full amount of the compensation that was awarded. If the worker somehow starts their retraining program before their impairment compensation is paid out, the impairment compensation, the largest part of it, the part for their work impairment, is held up until they complete their retraining program. Training programs can last 16 months, 21 months in some cases. So that can be a very long period of time for a worker to not have access to the compensation that they're due for their inability to do their regular work. And so the worker who gets that money in advance has that money to use while they're in retraining to create kind of a security fund so that they can try to complete their training program. The worker who's not able to access that money gets wage loss payments while they're in retraining, the same as they have throughout their claim. The challenge is many people fall behind on those wage loss payments, and it's a fixed income, and it doesn't have any cushion that they might need to keep themselves afloat while they're in retraining.
What do you mean fall behind on their wage loss payment?
They fall behind on their life expenses based on the wage loss payments. And we've heard some discussion about the 66 2/3 amount and whether that's appropriate or sufficient, whether that leaves the worker in a more difficult place financially than if they were working. Going into a 16-month retraining program and being locked into that same payment schedule for 16 months, that's a long time. A lot of things can happen. It's our sense that vocational services are underutilized. A lot of workers negotiate settlements and don't go through retraining, so they get some value maybe of their retraining and their impairment compensation and don't go through a program. We would like to eliminate barriers that prevent workers from going that route. And one way that we can see to do that is to try and allow all of the workers to be treated the same with regard to their payment of their impairment compensation. So the proposal would allow a worker to request a lump sum of their impairment compensation if it's already been determined, despite if they're enrolled in retraining or not. It would allow them to complete an appeal of their impairment compensation. So if it's determined and then a reconsideration is needed and there's appeal issues, if those get determined while the worker's in retraining, they would be able to request a lump sum. And the last part would be to allow the worker to put their program selection on hold until their impairment compensation can be determined, and frankly, until their impairment can be fully determined. If the worker's not, at that point where their impairment can be determined, and that's still a work in progress, how can they effectively select a goal that's going to be suitable for them in the long term? So this, the language seeks to decouple the retraining piece from the impairment compensation piece, so that there's not any kind of benefit at all to holding up, the slowdown of the closure and the speed up of the training. The pace of those things wouldn't affect the worker in the same way. It wouldn't create a detriment for some workers. If a worker's, in a challenging situation financially, they wouldn't be in a position where they had to negotiate settlement value or just give up their retraining and say, okay, now I want my impairment compensation. The other thing that we would like to do currently, a worker who is permanently totally disabled has to prove their permanent total disability before their claim is closed. So they have to prove that they are permanently totally disabled before trying to retrain, as opposed to going into retraining and then finding that they can't work at a suitable wage and complete retraining. We would like the workers to have the incentive to try to find gainful employment, so that they would not be stuck on permanent total disability. And we think that allowing them to try retraining, if there's a feasible way to do that, and then prove their permanent total disability after the fact would benefit them. It would give them a chance to try. But one of the things that a worker has to prove they're permanently totally disabled is that they want to work, that they would be working but for their disability, and that they're making reasonable efforts to seek work, or that would be futile. Well, how best to determine whether those things are present than trying to go through retraining? That's going to be the best evidence of the worker's desire to work and put in the effort. Workers right now can't do that. They don't have that option. So they either have to say, I'm permanently totally disabled and I'm going to put all my effort towards proving I can't work, or they go through retraining and that's not statutorily allowed to be reconsidered at the end of the training. That's another piece that we would like to change on that. Again, these things are designed to increase fairness and adequacy of benefits for the worker. It's not a problem that has been addressed previously, to my knowledge. I don't believe that this is something that was changed in the Mahonia Hall years. This problem affects a fair number of workers. I mean, a lot of workers do get their permanent impairment compensation before they start retraining. That really is the norm. I'm seeing more and more where the dates are getting closer and closer. Part of it is, in fairness, it is challenging in some cases for the insurer to close the claim. They do have to go back and get correct information, and if you appeal, it can be thrown out if adequate information wasn't obtained. But I'm seeing more and more cases where the retraining is being sped forward while we're still really trying to get at the impairment compensation amount, and that really puts those workers in a difficult position. The ones who've had impairment determined but haven't gotten a lump sum, they get a piece of their impairment, the piece for the physical impairment, but not the much larger piece for the work disability. And we heard a presentation about earlier, a couple meetings ago, about how those benefits are calculated, and the fact that impairment only is much, much smaller than the work disability piece that we're concerned about. Data in terms of illustrating the effect, we're trying to think through what data requests might help us get at that, because it is kind of a somewhat unusual situation in terms of how that would be tracked, how many people get their impairment compensation fully before starting retraining versus how many people are held up in that process. We're trying to think of some inquiries that might help us illuminate the scope. it doesn't seem to me like the cost, there should be a real cost added because these are benefits that the worker is going to be entitled to one way or the other. Again, it's a matter of timing and having the money when it's needed to complete the best they can in the training. We've spoken to the Ombuds office. This is another, another concern that I think that we share. So I do think that there's some support for looking at this as a concern. Workers and insurers would be most affected by this proposal, to some extent vocational consultants, but really more workers and insurers. And it's based on the timing of the benefit. We need to work with Workers' Comp Division to see if we can get some data that would give us a better sense of the scope of how this might affect things. But again, my sense is that these are benefits that the worker ends up being entitled to anyway. Questions on that?
Are there any questions from those in the room or online?
I'll ask
You have
one
one
if I'm
question?
just trying to pause, let someone, anyone else.
That's okay. Thank you for asking questions.
Yeah, so what happens if someone gets the award or an injured worker gets the award and then doesn't go through vocational training? I mean, what do they do?
The vocational training benefits are use it or lose it. You
Yeah.
can negotiate settlement value. So that would be potentially an option for a worker to negotiate a settlement value of the retraining. When there isn't a way to negotiate settlement value of the retraining by itself. So any settlement that includes value towards retraining also includes any permanent impairment that would be paid now or in the future, the retraining, any other monetary benefits that would go to a worker. So they're coupled in that way. There's not a way to say, well, I want to negotiate this, but I want to leave that part out. A claim disposition agreement covers all of those benefits.
Right, I guess that, does the worker get back to gainful employment, and does the worker really, go back to work and, do what our job is to do,
Well,
is to get them gainfully employed, and if they're not going through the vocational training and just taking the payment, I'm just wondering where that leaves the worker and that worker's future.
Well, that's a real problem right now, because what we see is workers who have to make this terrible choice, right? Whether I, for both of the pieces of this concept, whether I, forego training and settle my case, or just take my compensation and then deal with it myself because I need this money. I've fallen behind. I've lost my car. I've lost my house. I need a lump sum right now. Or they forego that lump sum and go through the training, but they might, lose a lot of their things along the way. And the same on the other side. We don't want workers to have to choose to settle their cases and give up rights that they don't want to give up only because they have to have the money now, money that they're going to be entitled to eventually, but they can't wait.
But I heard you say that they're not going through the training.
Some workers go through training, some workers don't. There are workers who settle all of their impairment compensation, their training rights, their future impairment compensation before they start a program. There are some workers who negotiate settlements for the money the insurer is going to pay out during the program. These are all things that are already happening. My hope and our hope is that we don't have workers that are in a position where they feel like they have to negotiate that settlement as opposed to completing the program. The goal of this is to enable workers to complete their programs as opposed to negotiating settlements. My personal sense is that workers are less likely to complete a program if they don't have access to the financial resources that they might be supposed to have. I mean, they are entitled to this compensation for their impairment. So where's the logic in withholding that impairment compensation for the whole course of the retraining? Why is one worker getting that impairment compensation and having that flexibility that they might need to ride out the storm and be successful in a program, and another worker is not getting that compensation and not having that ability? So I think you're asking, well, why should workers be allowed to negotiate out of their impairment? Their
No,
training?
I'm asking how do we get them whole and how do we get them back to work if they have this money and they're not going through their vocational training anyway? is our duty not done?
Well, I'm not quite sure I understand the question, I guess. My goal and my
No,
sense is.
I get, we
Yeah.
both have, I think we all have the same
Yeah.
goal. I'm just worried that, if they're giving us money ahead of time, maybe our goal's not being fulfilled if they're not going through training and becoming a self-sufficient worker again in the system.
The goal is, of course, to have them receive their impairment compensation, which is due to them, and then to do their vocational program if they are eligible for the vocational program. I think right now, it seems like there's sometimes tension in choosing which one they do for financial reasons. And we want to take away that tension so that a worker can say, I'm going to pursue my full impairment compensation, be that appeals or whatnot, and I'm going to do my vocational program. We can't fix workers who don't want to do their vocational program in the first place, but we can at least provide them with financial incentives and not that tension in figuring out what to pursue and what not to pursue at a point in their claim when, we have to, all of these workers are seriously injured workers with accepted conditions that everyone agrees have problems that they can't go back to work. I mean, that's like the baseline about these sorts of workers that we're trying to make sure are treated equally.
So the concern is that if more workers are getting their full impairment compensation and then deciding whether to go through retraining, that since they have their full impairment compensation, they say, I've kind of got what I need and I'll not
We
go
don't know
through.
that, right?
Yeah, right. No, I understand, but that could be a concern. And I guess I would say that most workers are already getting their full impairment compensation before they start retraining. It's just aggravating when you see a claim that maybe a worker that's been medically stationary since June and the insurer is supposed to be collecting the information and figuring out what is owed for their impairment, and you get to December and that still hasn't been done. And meantime, we've had 3 conferences about when is the training going to start. There's a tension there. Then I'm seeing more and more of it as things are, maybe more technical at closure, but maybe not. Maybe it's just slow in asking the questions and getting to the doctor, and maybe not wanting this doctor, maybe wanting a different doctor, an IME for the closure. Maybe our doctor's willing to speak to the questions, but the questions haven't been presented. We'll just get an IME. It'll be in 2 months. There are things that are delaying closures frequently and putting workers up against the time where they maybe have a claim closure and they're thinking about needing that lump sum, but they also see an issue for appeal. And maybe that issue is a $5,000 issue, but if they open it back up again, well, they're going to be waiting 16 months to complete their retraining program. These are the types of situations that I'm seeing more and more of, and it really puts the worker who's in that situation in a bind. We want workers to complete retraining and become whole and become, contribute to society as much as they can, but tying those two things together creates a problem, and I'm not clear what policy supports tying those two things together in a situation where the worker has to make that choice and choose between the two when they're entitled to the impairment compensation. They should have some choice in that matter when that and how that plays out, and not just be set to wait.
Margaret?
Yeah, the one thing that I am kind of missing in this conversation is it seems that when we're talking about, just tying the impairment and the timing, it kind of implies that the road to eligibility for vocational rehab is just like a smooth, flat sailing, thing. And I just wanted to ask you to kind of comment on that part of the impetus on workers to settle their claims or to remove themselves out of the system.
I'm not sure I could quite understand that question. Can you kind of?
Well, yeah, I'm getting the impression listening to this that the road, like if a worker can't return to his job or his or her job at injury, that there's mandatory retraining.
No.
Yeah. And so let's make that,
Yeah. So the determination of whether a worker is eligible for retraining is made usually once someone said the worker has reached maximum improvement and has given some work restrictions. Now, sometimes that will, they've been given maximum improvement and they've been given work restrictions. The two of those things together suggest that those restrictions are permanent. And sometimes, in some cases, that triggers a eligibility evaluation for the retraining, where they look at the worker's previous skills, education, and physical capacity. And you do a calculation. What was the worker earning before at the time of injury? What could a worker realistically have the skills and capacity to earn now? They compare those two, and if the worker isn't able to make at least 80% of their wage at injury, that's when they become eligible for retraining. At that point, once they're eligible, then plan selection begins. The goal is to restore the worker as close to 100% to their wage at the time of injury. So there's a limit, and if a worker requires very little retraining to get to 100%, maybe just some on-the-job training, the training can be very short in duration. If a worker has a major loss of earning capacity, the retraining goals can be 16 months or 21 months in some cases. But a worker has to work through the options, the goals that are within their physical capacity and within the scope of the training. There's a limited dollar amount for the training, and there's a limited duration for the training. And all of those things have to be worked through. And sometimes workers select a goal and then find that that goal isn't going to work out. And then we go back to the drawing board and we select a different goal. But there's timelines, and the insurer, if they want to, can refer the case very early for an eligibility evaluation. If they wanted to, they could wait until they've got the other information needed for closure and do the claim closure and the calculations of the impairment. The challenge that we run into is when the closure part takes a long time and the eligibility evaluation is done right away, and then we're answering questions about when are we going to be enrolled in a plan. Does that answer?
That's, yeah.
A little bit
I think there was just, I was missing that little piece that in terms of what is in the impetus for workers. I mean, you answered it. Don't worry.
Yeah.
And also that just for completeness, employers can make a choice at closure to offer a permanent light duty position to the worker, and then that worker does not get vocational benefits. They get their
Right.
impairment compensation, but then they go back to their employer
Right.
and work. And so that's certainly one option there. And then also during that eligibility evaluation, someone can be found ineligible, and that is an appealable decision that goes through the workers' comp division.
Causing another I don't wanna
Additional
say
delays,
delay in
additional
benefits.
time, and that goes through kind of an informal conference period. So it's not like a hearing where you have very rigid timeframes. It's kind of a process to see if the parties can come to a determination or an agreement, and if they can't, then there'll be a decision, a non-appealable decision, I'm pretty sure.
Yeah, thank you for that example.
Yes,
It made it more clear to me. Thank you, Keith.
Yeah,
Ryan,
yeah.
I have a question.
If I understand the process correctly, so, when they're determined that they're not gonna be able to return to work, they're given that work disability award. Let's say they have a grade level of 9. Once they finish that training program, and let's say that grade level is now up grade 12, that work disability gets reassessed. Is that correct, the amount? So if they request that lump sum now, and then that benefit is reduced based on their completion of the training program, do we recoup some of that money that was already paid out front? Does that make sense? Or is the worker essentially?
I've never
coming
seen
out
that
ahead?
money recouped
Yeah.
from those workers who are in that position of getting their impairment compensation first. I know that there is a redetermination,
Yeah.
but I haven't ever seen that be recouped from the worker.
And as a policy matter, the worker is the one going through school, right? They're putting in a lot of effort and time away from their families, away from other employment to go to school. And so as a policy matter, we think that any gains in those abilities should break towards the worker, because they're the ones who receive that goal, not be refunded to the insurer when that was already determined at the beginning.
Gotcha. Thank you. Follow-up question. We had mentioned earlier, really what seems to be the crux here, or the crutch is their financial stability while they're going through retraining program. And it brought up about average weekly wage. That's something that I think the committee is looking at as a whole. If that was increased, or if there was an answer to the average weekly wage, could you see that positively impacting this situation? Right? Kind of a roundabout way of answering this
Yeah.
whole situation in
Yeah,
itself.
certainly. We heard from, an injured worker last time about who with an accepted claim, and how he just kept falling further and further behind because, his tax rate wasn't 33%. So that would certainly help workers in not falling further and further behind. It doesn't necessarily answer the question of this impairment compensation belonging to the worker under our rules and them having an entitlement to it, and then workers being treated differently based on timing. But it would certainly help those workers. Any help to workers to not fall behind financially is a positive.
Absolutely. Thank you. I appreciate it.
All right, so ready to move on?
I think so.
All right, so moving on to our last legislative concept, parity in disputes. And so workers in almost all situations improving their benefits have the burden of proof. So they have to prove entitlement to their benefits. And we're seeing more and more as medicine and law gets more complicated with the notice requirements with time loss now, with the complication at recon, that's requiring more and more contact with the medical providers to get records, to get reports, to clarify a position the doctor maybe previously took or said in a chart note. And right now, when workers are successful in some types of disputes, they can be reimbursed some of that money, with the concept that workers should not have to spend their own money to receive their benefits. If they were entitled to those benefits anyway, they should be able to recoup specific recoverable costs, but only in some types of disputes, even though these sorts of costs need to be incurred in all sorts of disputes. Also, those costs are severely limited at $1,500, which I believe was set in statute in 2005 and has not been updated since. I can tell you I started working in 2007, and paying $150 to talk to a doctor and get a report was very normal. Now, if it's under $1,000, you feel lucky. That's how much doctors have increased their costs in speaking to attorneys on both sides. And insurance companies can spend any amount of money they want and don't have to tell us how much money they spent, but workers are limited to $1,500 per hearing and limited to compensability disputes. So full claim denial or a new or omitted condition. And there is an extraordinary circumstances caveat, but in practice that is very, very difficult to actually utilize and ends up causing litigation if you spend over $1,500. I believe there was a case that went up to the Court of Appeals where the worker had spent $1,550, so $50 overwards, and there was endless litigation over that $50. So it's just not working how they have it right now. It hasn't been updated and it's not working. And the real problem on the access to justice side is sometimes this setup prevents workers from actually asserting their rights or contesting denials of their benefits. So if we look at current law versus what our concept provides, current law, payment for witness fees, expenses and costs may not exceed $1,500 absent extraordinary circumstances and only applies to those compensability hearings. We would like to remove the $1,500. Putting a set number in statute is always dangerous, it expires quickly. And we believe that the decision maker, whether that be an ALJ or the director, the decision maker who heard the matter and decided it is in the best position to decide what costs were reasonably incurred. And so we take the cap off and we let the decision maker have the power. We remove this unwieldy extraordinary circumstances. It won't be necessary anymore. That will help, take away some of the litigation. It also allows workers to spend the money they need to pursue their cases. I recently won a medical services case. So a question of, whether a worker with an accepted surgical claim needed rehabilitation after that claim. The insurance company submitted 26 medical reports to say that this worker did not need this benefit. And my worker was seeing 3 different doctors because of the complicated nature. I had to get 6 medical reports to beat those 26, and it cost me nearly $6,000. Now it costs the worker, right? Because I was paying the money, but the worker's ultimately responsible for that. And she couldn't afford that, of course. And in that one, the insurance did argue that it was a moderate case and I should not be awarded more than $1,500 in costs. And I did prove that my entitlement to those costs under that very specific situation. But that is an outlier case, right? What we see all the time is 2 to 3 independent medical exams, which then we have a treating doctor who needs to rebut and maybe write 2 or 3 reports as the reports keep coming in and the burdens keep shifting throughout a matter. And that can get a little over $1,500 sometimes. Also, sometimes you have multiple hearings, like you have 3 different conditions, so you need to talk to 3 different doctors. But if it's only in one hearing, you only get $1,500. And so we also want to expand this to not just compensability hearings, because as I mentioned, what happens is that in some of these really important benefits to workers, but the value of those benefits is low overall, there's no ability of the worker to go get a medical report. I had a case a few years ago where a worker was not reimbursed for medication that his attending physician prescribed to him. He paid for it, he requested reimbursement, the insurance company denied it because the doctor hadn't given the insurance company something it wanted to approve it. Not that the worker knew that. It was about $300, and my worker really needed that money. He was, like, I can't pay my rent without this $300. And I had to tell the division in my filing, I would go to his doctor and ask him why he prescribed these. But I know this doctor charges $250 to even look at a piece of paper and check a box. I can't go spend $250 of the worker's money trying to get him $200, because in medical services issues, you don't get your costs back. So that worker, if I had to go out, he couldn't even go to his doctor saying, why didn't you do this? Because it would have cost him more than trying to get that benefit. The same at reconsideration. This happens at reconsideration a lot. As we talked about, everyone's trying to get information from the doctors about the impairment and the return to work, and it might be unclear, right? Happens a lot. My doctor told me this, and now he's written this. I want to go talk to that doctor and ask him what happened, both so that we can make sure the worker's benefits are administered correctly and so the worker knows what's going on. Now, if I go out and get that report from a doctor and that ends up with worker getting more impairment or maybe more time loss because the doctor said, actually, I didn't mean to take away these 2 months of time loss. I meant to give, I meant it a different date, or the medically stationary date has changed. There's attorney's fees under the law, percentage attorney's fees for that sort of thing, but no recovery of costs. So, if I get the worker an extra $10,000 in permanent impairment, for example, in recon, because I spent $500 talking to his doctor, well, $10,000, I'm going to get a $1,000 attorney fee on that. Am I going to go to my worker and say, give me back that $500? I'm going to probably not. Now I've just basically worked for free at recon, and the worker, if the worker doesn't have an attorney who's able to pay those costs, I would have had to go to my worker and say, your claim was just closed, we disagree with it, but I need you to give me $500 so I can try to talk to your doctor and see what they really meant. And by the way, that money's gone, regardless of whether that effort caused us to be able to now get you more benefits. And so that's our solution to, expand the costs so that workers have parity in disputes, because of course, insurance companies can have no limits on how many reports they can get, and workers are already at a disadvantage in litigation because we're usually needing to go to an attending physician, a surgeon who's treating doctor, not a professional IME person. So we're already at a disadvantage, and then we can't spend as much money, and then we can't spend it on the things we need to without dipping into the workers' benefits that we're trying to recover for them.
There's already been, in terms of how the proposals support the values of MLAC, there's already been a recognition that reimbursement of litigation expenses is appropriate to help level the playing field between the worker and the insurer. It's been recognized that we need a $1,500 cost reimbursement in compensability disputes absent extraordinary circumstances. So we feel like the idea that this promotes fairness and equity in the system is already established. The question is, why should that not apply to other types of disputes other than compensability disputes, where we also require medical evidence and also see a lot of medical evidence being obtained by the insurers? I believe that this problem, if we look back at the legislative history when cost reimbursement was adopted, that there was a recognition that workers could be outspent, that these medical reports are very expensive, and that workers wouldn't have access to justice if they weren't able to recoup some of the costs associated with the litigation. And we think that the proposal that we're proposing increases flexibility because it puts the decision maker, the adjudicator, in the position to decide what's reasonable in terms of those expenditures. So if we were just throwing money at a claim right and left, and we went way over the what we were seeking a large reimbursement, and the insurer said, maybe it's less than $1,500, and it's not reasonably incurred. Maybe we spent $1,500, but the decision maker said that's not a reasonable $1,500 to spend. They would have that ability, much to my chagrin. I mean, but they would have that flexibility. It would at least give the worker the ability to contest the benefits that they feel they're entitled to, and if they're successful in proving that they're entitled to them, then they would get the full benefit without having to consider what money they spent out of pocket to obtain the benefit. So this issue has been addressed previously, but we found challenges with the way it's worded and the nebulous term extraordinary circumstances. What may be extraordinary to one person may not be extraordinary to another. What's extraordinary in cases where we frequently see 10 or more medical reports. I mean, there's a lot of cases where we're just seeing, since I've been involved for about 20 years, it's just gotten every year, there's more and more and more medical evidence, in addition to the fact that our treating doctors are charging us more and more whenever we need to talk to them. We have to respond each time we get new evidence. Each side is trying to get the last word. If you don't respond to someone's statements, if your expert doesn't respond to their expert, a lot of times they're deemed to be less persuasive because they left an unanswered question hanging. That pushes us back to the doctors more frequently to satisfy the burden of proof. This problem affects pretty much all workers that are dealing with disputes over benefits, because they almost always have to go and get their doctor to comment. It specifically affects those with more complicated cases that would require more than $1,500. Maybe you have one hearing, but you've got 3 or 4 different body parts that you're talking about, and different doctors with different specialties. It could start to exceed $1,500 very quickly. And the other thing is the workers who just don't have the ability in certain types of disputes to get any of those costs reimbursed. We do always have to think, obviously we're presenting it from our experiences as attorneys. There are unrepresented workers. They have the right to be unrepresented. They should be able to navigate the system without an attorney. I wouldn't advise it, but they should be in a position that they can do it. So there really shouldn't be, this isn't an attorney bill for us to pad our pockets. We can just tell folks that we can't help you with your costs, and if you don't have the $500 to talk to the doctor, sorry, we should settle or just go away or just not get that prescription filled. We try to avoid that, but we definitely have to think about this problem as not the attorney intermediary getting paid back. This is money that would otherwise come out of the worker's pocket. In terms of the costs, it's difficult for us to estimate. I think we would need to start and try to get a handle on what's being spent currently, but it's really difficult to kind of prove, to figure out what additional expenses might be reimbursed because they haven't been reimbursed. We know how much the doctors charge us. We know that the doctors charge the insurers when they ask the questions, so it's not unusual for insurers to pay the money to doctors in their cases and in other cases. But it's difficult to estimate the potential costs, and we know that's going to be a topic of discussion and concern and consideration. We have done outreach with SAFE, with AGC, with the Workers' Comp Division, but there's plenty of others that we need to do outreach with to talk about this concept. And a lot of the expense depends on whether it applies to all disputes, whether there's any, ultimately, if there is any dollar threshold where it does need to be extraordinary. That's not how we've written the bill. That's not how we want to see it go, but changing those things could affect the cost estimate. So we will be talking more, getting more positions from affected stakeholders, but we talked to some at least to get a sense of where they're at on this. So that's what I have.
Okay, well, thank you for providing those answers. Are there any other questions from the group?
How often are we seeing disputes go to hearing as far as on costs at the WCB? Any statistics on that, or?
That's a very good question. I haven't seen any statistics on that. I think it's fairly rare. And, you know, I did mention that one case that it was $50 over and a lot of litigation. I've had a few cases where it's been just a little over. I think I had a $2,200 case, and I, you know, explained to the attorney why it was reasonable, and they ended up just agreeing to it. So that does happen sometimes. I would also say that, you know, when I do cost bills, usually they're under. I mean, usually we can still do it under the 1,500. I don't think that's going to change. But for those more complicated cases, or where you have to go back, especially to a surgeon multiple times, then you might get up into the, you know, $2,200, $2,500 range. And so, yeah, some statistics on that would be good.
How often are you maybe pulling back on your investigation because of that cost cap? Like, do you ever evaluate a case and go, well, we could go this avenue, but it might go over that 1,500 limit. I'm not going to go that avenue. I'm going to go this route.
Yeah, absolutely. It's a discussion that has to be had with the client and an assessment of the case. And, you know, the clients are responsible for this money. You know, it is their money to spend. And so, yes, I have had cases where I've said to the client, do you want to spend $500 to go talk to this doctor? And they've said, no, I can't, you know, I can't spend that money. I don't want to risk that money. Yeah, it's a real concern. And it also oftentimes affects who we go and talk to. You know, if someone's treated with multiple doctors, sometimes you have to pick, right? You have to just choose one and hope that that doctor, you know, is representative of the opinions, because you simply can't afford to talk to 5 or 6 doctors.
Thank you.
Sarah, did you have a question?
I too would appreciate more information on the stats, and I like that you're working with SAFE and other insurers on this to come up with something that works for everyone. So thank you for your efforts on that. I have a question on the clause, but not limited to. What is the intent of what should be covered under that? Not limited to clause.
Yeah, I think right now in the statute, it sets out some very specific things that can be reimbursed. And sometimes there are costs reasonably incurred that go beyond those things. And again, the decision maker, the adjudicator who's deciding it, would then have the power to decide if something that isn't necessarily specifically fits into one of these boxes on the list was nonetheless a reasonably incurred cost. That could be something like an interpreter, you know, a sign language interpreter, so you could communicate with your client. Those currently aren't recoverable. You know, could an adjudicator decide that that was a necessary, reasonable expense under the, you know, the change in the law? Yes.
So your intent was to include interpretation in that. Is there anything else on that?
Oh, sorry, it wasn't our intent to include interpretation. It was just an example off the top of my head. I think when Elsie drafted this, the intent was to make it more, put the power in the hands of the adjudicator to decide what was reasonable.
We've heard that question, and we're also thinking about it before that was the question that came up with SAFE as well. So we're looking at that in terms of
the, you know, ambiguity. I hear is a challenge, right? So if we could, you know, get rid of the ambiguity, it would be clear for everyone.
Yeah, absolutely.
Ryan Hearn has one more question.
Thank you, Co-Chair Priest. So working on that interpreter situation, you know, let's say a firm has employed somebody who, you know, works the front desk, but is also bilingual and is supporting, you know, case evaluations with that attorney. Could they then bill that interpretation fee, right, for their employee to the insurer?
I think it would depend on how a judge thought what was reasonable, and the you know, the attorney, just so everyone's clear on the process for this. It's not just like, you know, the judge orders costs and then there's a cost bill that the attorney submits with the dates and what they incurred and why they incurred it, and then there's a chance to, you know, dispute that. So it's not just you know, send me a check for $4,000, thank you. So yeah, it would have to be something that would have to be looked back and forth, and like Keith mentioned, this is something that was pointed out to us very recently by SAFE, so we haven't fully digested that yet, and it's you know, really well taken point. We don't want to end up having more ambiguity when part of the purpose here is to create less litigation.
Perfect, thank you. I appreciate that.
Thank you, good question. Any other questions? Any online? Okay, all right.
Thank you all for sticking with us. It was
Sure, yeah.
I know it's a lot of information. I appreciate your patience and your time.
So did you get what you needed from us then? And it sounds like you'll come back.
Yes,
something
yes.
else?
I meant to say at the outset that we weren't seeking a vote, that this is informational, that these concepts are a work in progress. We didn't get exactly the language that we were seeking based on what we sent LC, and we know that we still have discussions that need to be had and probably amendments that'll need to be made. So we'll try to bring a more finished product back, and then kind of speak to some of the questions that have come up today.
All right, well, thank you very much for your presentations. All right, with that, we move on to our next item on the agenda, which is the 2025 legislative overview. And we have Teresa Van Winkle here to present that to us.
Hello again. I'm going to apologize to you if I go back and forth like this. I'm nearsighted, so I need it more for the screen back there. The actual words too. And also, since I'm the last standing item before we adjourn, I will be as succinct as possible. But I also want to make this open, have an open forum for any questions that you have throughout the presentation. So I was asked by Terry to put together some information for you all, kind of a high-level overview of the legislature, kind of the makeup of session, timelines and such, and also kind of go behind the black curtain on how legislative committees do deliberations and utilize information that MLAC does provide. For my background, actually, before working at DCBS, I actually was an administrator for policy committees in which workers' compensation bills were in front of. So I actually attended MLAC as a policy analyst in a different capacity. So I know what happens behind the black curtain, so to speak. Okay. So the legislative body. So Oregon, like most states, has a bicameral legislature, 60 House members elected every 2 years, and then 30 members of the Senate elected every 4. So each of the chambers, House and Senate, they appoint a presiding officer. In the House, it's the Speaker of the House. Senate is the Senate President. And it's elected by each body. So it's not based upon political affiliation. And then also in turn, each of the chambers have a caucus office and a caucus leader, and that is based upon party affiliation. And those offices do have policy analysts. And so you may see that they also attend and monitor MLAC as well, depending on their policy portfolio. So the primary role of the presiding officers, besides managing each respective chamber as a whole, they're responsible for actions such as the referral of bills. They also establish committees, the committee structure, and also the committee membership, and also dates and the standing times in which they meet as well. Going back to the body as a whole, prior to and during session, this is right now at this time, this is when Terry, myself, along with lots of other entities, do reminders to legislators, legislative leadership offices, and also committee analysts on various topics. So, for example, in talking to staff and rank and file members and committee chairs, this is when we also talk about the MLAC review process and provide that information as well. So the Constitution establishes the deadlines, the maximum times in which a legislature can meet during a long session, which is the odd number year. So the 2025 sessions that are considered a long session, even number of years is shorter. So in 2025 session, they can meet a maximum of 160 days, or the constitutional sine die for 2025 will be June 29th. They can adjourn earlier, but since these have been in place, they tend to be more towards the end. They can extend the time if they so choose, but that's not happened yet, and that takes a supermajority from both chambers and all that. And that bridge has not been crossed yet by the legislature, so there's that. Next Monday happens to be, they call it day one of organizational days. It is actually the constitutional opening day. So this is when the legislature as a body does their organizational activities. So this includes the swearing in of those that are newly elected, the election of the presiding officers, and a couple of other positions as well, including the parliamentarians. It also, for us in regards to the process, this is when the bills that were pre-session filed have what's called their first reading. They're formally introduced, and then in turn after that happens, that is when the information is known as to which policy committee or committees that a bill goes to as well. The also part of the organizational process includes what's called a resolution, which is a declaration of when the timelines for session. So for the 2025 session, there is what's called the first chamber deadline and the second chamber deadline. This is standard for every long session, short session. What the first chamber deadline is this is when, for example, like a House Policy Committee, this is a deadline for them to do final deliberation on House bills that are within their committee. Likewise, for the Senate committees, it is for that. There are exceptions for these deadlines, and the second chamber is for the opposite chamber bills. There are exceptions to this, which includes the budget committee, what's called the Ways and Means Committee. That committee, the revenue committees, and what's called the Rules Committee. So for those of you, the Senate Rules and Executive Appointments Committee, that is the Senate Rules Committee. The House has a similar name. And also any joint committees the presiding officers choose. They can deliberate on bills clear up until signing time. So again, that's why I mentioned like the last day of session, if we go into sweeps or any other last minute things, that's what happens then. Also too, and knowing the chamber deadlines too, there's also, because of the deadlines, there's also like a flourish of activity surrounding that. The bulk of MLAC's work historically takes place up until that first deadline as well. Maybe sometimes there may be some cleanup work, there are some continuing conversations that happen afterwards, but having these deadlines too also helps with Terry working with co-chairs in your work plan and making adjustments as necessary.
So April 9th,
April, yeah.
just flagging it.
I'll refer to something. Yes, I actually have a document that refers to that later on in the slide deck, and I can actually extrapolate that, give it that to Terry as a standalone document for you all. So again, next Monday will be when bills will be officially revamped. The legislature does, as a courtesy, provide the bills in advance. That has not happened yet, unless it happened since I've been sitting here. I've heard it will happen tomorrow. But no matter when it happens, we have DCBS has a process on how we look at legislation and how we have a standard criteria of the importance of the bills in regards to things such as so specific to workers' compensation. If there is a impact, positive or negative, to the various parties within the system. If there is what's called a fiscal impact, which for us, a fiscal impact is if there is an impact on program operations and programs, or if there's new as well. And then also too, if we have to do additional things such as to carry out a bill's legislative intent, if we can't absorb it with existing staff, if we need to have a different data collection system and hiring a vendor to carry out the functions, the deadlines, that sort of thing as well on that. We also identify two bills that have impact too on regulated industries as well. So there's that. I should also point out too that each of the divisions within DCBS has, we have standardized process, but they have their individualized processes. I will point this out because of SAFE and other workers' compensation carriers. We have a separate division, the Division of Financial Regulation, that does evaluation of insurance bills. So looking at SAFE bills as a carrier, they are not involved in deliberations on how anything within the system itself. So I want to point that out. SAFE SAFE has to work with two of our divisions on a regular basis, along with the other insurance carriers as well. So after divisions look through and identify bills and they're triaged, so I'm going to speak specifically to WCD's process. Their policy analysts are assigned to a set of number of bills to do a bill analysis, which is the impacts. Once we get the bills and the bill analysis documents have been completed, these are the same documents that will be in front of you. So to summarize what these documents are, it is what current law is, what the bill proposes to change, subtract, delete, what have you, and then other pertinent information as well. What this also includes if the bill has this ideas within the bill have been in a prior session bill or specific, from time to time we do, MLAC does have bills in front of you that focus on the catalyst was case law. That happens fairly often. It hasn't, I feel like I'm jinxing it by saying there will be one, but but that does happen from time to time as well. We also, to WCD, along with other divisions, and this includes myself in the director's office, we also prepare for committee hearings. We monitor agendas, see what happens. We also are often asked for technical questions. The bill analysis that WCD provides also can be provided to committee administrators to help with their nonpartisan analysis for the committee as well. We are also sometimes asked from time to time to be in the hearing room in case there's any technical questions on that as well. But we do not take a position on any legislation as an agency unless it is an agency bill, so our agency budget, the bills that WCD, the LCs that Matt presented earlier, we can say we support those because they come from us. We also can ask for permission as well, but you do not need to worry about any of that. I just want to point that out as well. And sometimes too, I should point out for Terry as well. So Terry may from time to time also, if there's a general question specific to MLAC, that means Terry can maybe asked on the fly to speak on your behalf as well. And sometimes too, the co-chairs are asked as well for formal input as well. So I won't go into detail here. Oregon is rather unique that we are one of a few states in which any changes on the bill, deliberations on the bill are really exclusively focused on in the committee structure. Most states, when the House or the Senate, when they're voting on the bill, most states can amend right then and there without any public deliberation or even advance notice this was going to happen. In the committee structure in Oregon, no, it's all based here, and there are set timelines too for public notice and public input as well. Unfortunately for MLAC, the bills that are assigned to policy committees, the policy committees rarely focus on one public policy topic. So workers' compensation focused bills have to, be heard, compete for time along with lots of other policy issues, just depending on the scope of the committee as well. As with MLAC, there's hearings in which people present. The public can provide any input, opposition, and all that. And then there's also, before a bill is voted out, they have to do what's called a work session, in which it is public deliberation. It is not, the public cannot speak to it, but the committee chair can choose to have invitees be either available for questions or actually speak. It just depends on, so for example, it's parallel with MLAC. When you have questions, the work session is kind of the same thing. If there's questions that need to be put into the record, that is when that happens. Also, too, specific for MLAC, the use of information from MLAC, the work session is typically a second opportunity and along with a public hearing to reiterate MLAC's position on the bill. And so what happens on our end is when you make recommendations, the recommendations are put in a letter that comes from the co-chairs, and it is entered into the record as well to do that. Typically it can happen, the letter can be put into the record when there's a public hearing, but more often than not, it may be during the work session because the work session often is not scheduled until if there's activities that MLAC would like to have completed. So for example, hashing out amendment language or anything else of that nature, they wait for MLAC's deliberations there. So. Let's see, I'm gonna skip over this one. This slide just gives the indication of the actions that a committee can do. I should also point out too that the work session too, from time to time, they don't have to vote out a bill. There are times in which a committee realizes that they don't have enough time to vote on the bill. There needs to be more work done on it. So they often ask MLAC to look at, add a topic or that, items in that particular bill to be put into the work plan during the interim, which is a time period from one legislative session to another. So that everybody has ample time to speak and hash things out, if you will. So kind of going back to answering Margaret's question in regards to the statutory functions of MLAC. MLAC's role in the committee in the process is again the legislative review process, which is happening now, in which again, like a legislative committee, and just what happened at this here, this meeting and others, is asking for clarification on proposed legislation. And also then in turn, when you have your votes, making recommendations related to legislation. And as a reminder, for those who have not followed MLAC or new to us in the process, under your committee bylaws, MLAC can support or oppose or table a bill, which would be reflected in the letter. And it also can include too, if there's other follow-up activities that MLAC would like to do as well. That would be in the formal recommendation as well. I should also point out too that although historically, I do know this from just as an observer and a direct participant in the committee process, the legislative body does respect and take highly into consideration your work and your efforts, and and also in creating consensus bills and amendments and such. But they are not statutorily obligated to carry out MLAC's recommendations. It is advisory in nature only. But again, because of the volume of detail and consideration and deliberation, they typically, they more often than not do it. So to go back to Sarah and just kind of, so I put together this timeline, and it's over the next few slides, that incorporates the current committee, your scheduled or penciled in meeting dates with deadlines at the legislature. So this is just a reference document for you to have. And again, I can extrapolate this and make it a standalone document for you all. I should point out that too, that particularly during a session, those are just we have those weekly meetings in place, or bi-weekly meetings in place, for the legislative committees to have that information at their fingertips, to help with their work plan as well, in setting up their hearings and work sessions as well. I feel I don't want to jinx anything, but really the volume and the frequency that MLAC meets during sessions specific to the legislative review process really depends on the volume of bills, the amount of work, etc. So that is really up to the work plan as well. I don't want to speak on behalf of Terry or the co-chairs as far as frequency. It's kind of one of those things where it's not set in stone. But I know that the work plan does get adjusted as session progresses on. Yeah, so I'm just going to skip through that. I just have so through here. It also includes the constitutional signing by date as well. The last two slides are items that are on the legislature's website. This is what I call, for those of you who are familiar with Schoolhouse Rock from back in the day, this is Oregon's version of I'm Just a Bill. Just very, get a very high level of like how an idea comes from start to fruition becoming law. If you really, really want, I believe Legislative Council, which is the drafter of legislation and amendment bills and amendments, has a actual like more legal like white paper if you would like that.
You guys all, I'm sorry,
no, go
I
ahead.
didn't mean to interrupt. You guys all have copies of that and copies of the schedule in your files. So yeah.
We get them electronically. We didn't get it electronically.
Not electronically. You have it right there in front of you.
Can we get it electronically?
Oh, can you get it? You can, the calendar. I tried to.
Yes.
You can.
We
Yeah.
have a PDF version, and actually, Kara, I do have a standalone of the diagram as well.
Oh, okay.
And I do have a PDF of that timeline I put together. So so I can.
Yeah. I didn't. Make
So we'll
a
do
copy
3
of that.
separate documents.
Yes, we'll get it out.
And so last but certainly not least, this is the last 2 slides are this is the official legislative developed session calendar. So it has all of the dates and timelines and such for that. So that is that.
Well, thank you. That was super helpful. I know we've talked about that in years past, and that was the best overview I've gotten. So it took 4 years, I guess.
Yeah, and I should also going back to the review process too. This is also how between Terry and myself identify bills that go from you, the co-chairs, for what's put to have under the review as well.
Are there any questions from the committee on that material or comments online? Are there any? Okay. Scott, you went off camera. You have your hand raised.
Yes, I just wanted to thank Teresa for the presentation. That's super helpful, and I think it's very nice to have that multiple multiple different ways to understand the calendar moving forward. So yeah, thank you.
Thank you, Scott, for that. All right, well, before we conclude the meeting, at the very beginning, I was eager to get to the minutes and I skipped over public comment. So is there any public comment from anyone in the room? Those behind me? Anyone? Okay. I hear-
That's
see
brutal.
none.
You made him wait till the very end.
And then online, is there anyone that had anything that they would like to say? Okay, hearing none. We did conduct all of our business other than announcing that our upcoming meetings are January 23rd and the 30th, and those are both virtual. So thank you for coming in today. I think meetings, I don't know, I think they're better in person, but they'll be awesome virtual meetings.
Yes, they will. Yes.
And with that, I will adjourn the meeting. Thank you very much, everyone.
Thank you.
Thank you.
All right. Good to see you all.
Yeah.
We made